Great. All right. Good afternoon. This is the meeting of the Right to Know Advisory Committee Public Records Exceptions Subcommittee. I am Chris Parr. I am facilitating this meeting, and I represent law enforcement interests on the committee. We're going to ask each member of the committee to introduce themselves, and when they do, once they've introduced themselves, to pass it on to the next person by naming the next person who should introduce themselves. So I will pass it on to Eric.
I'm Eric Stout, the IT member on the committee, and I'll pass it to John Bolton.
Hi, everyone. John Bolton. I'm an Assistant Attorney General, and I will pass it to Kevin.
Kevin Martin, Maine DEP. Normally representing government interests. I think I'm also representing that here. So I'll pass that on to Julia.
Oh, Julie's fine.
Sorry.
I'm going to change.
I heard both the ones on the day.
Hi, I'm Julie Finn, and I represent the Maine Judicial Branch, and I will pass it on to Linda.
I am Linda Clancy, and I represent the Maine Press. And I will pass it on to Colleen.
Thank you. Colleen McCarthy-Reed. I'm one of the staff people for the Right to Know Advisory Committee, helping you out today. So I'll shift it off to Peggy.
Hi, I'm Peggy Reinsch. I'm one of the OPLA people helping to staff today. And I'll pass it on to Rachel, who's new to the advisory committee from our office.
Good afternoon. I'm Rachel Olson, and I am also one of the staff people helping out the Right to Know Advisory Committee.
All right. Excellent.
So you also have two friends who are here with you today.
Exactly. I will ask them each to introduce themselves. I'll just go ahead and start with Kate, if you could.
Sure, thanks. I'm Kate McBrien. I'm the Maine State Archivist. And Brenda?
Hi, and this is Brenda Kelty. I'm the Public Access Ombudsman for the state of Maine.
All right, great. So if that were our agenda, we'd be done, but it's not. So that was item 1, though, and there are 7 items, and we're going to move right into item 2, which is existing public records exceptions that were tabled from 2020. Now that we've received questionnaire responses as well as a chart that includes cross-references to the statutes that include the exceptions. And what I was thinking, if it would work, is if I'm going to go ahead and start with Eric again, and then we can kind of pass it off like we did to each before, and ask that you each identify exceptions citing the reference number of those exceptions that you think some discussion is required about, or you have concerns about the exception as written, or the fact it exists at all still. So for example, I'll just go first. The reference numbers that I had concerns or felt like I wanted to ask some questions about are 2020-5, 2020-11, 2020-44, and 2020-46. And so now that I've gone, maybe if like I said, why don't we start, Eric, I'll start with you again, and then we could go around to each member accordingly.
Yeah, so thank you, Chris. I think that's a good approach. I did spend a couple of hours reading through everything. I started with the charts, and then I went to the agency responses. I wish I'd done the agency responses first, because they did a really good job summarizing what it's all about and their rationale for why it's still needed. And there was one instance where they said that they don't need it because the law has been repealed. But having spent a couple of hours going through it all very carefully, item by item, I from my point of view, I felt like everything was well justified and should stand as is. In particular, the gambling board items. My first sense was, that there should be a lot of eyes on that because of so much money involved. But as I read through the statutes and the agency explanations, I did feel like that there was a lot of auditing and oversight and mitigating controls and all the things in place that relieved my initial kind of concern about, are there enough controls over these activities? So in the end, my conclusion is that for each item, individually and collectively, I thought that the rationales were good. And in particular, the song I like to sing is about privacy information. So I thought each of those where that applied, that it's a good balance. So that's my conclusion.
All right, great. And who will you pass it on to now?
Let's go to John Bolton again.
I think you're muted, John.
Sorry about that. I read through all of these as well. I didn't really have a lot of concern about any of these. I agree with Eric that they're all, I thought they were well supported where the agency had a position. And I certainly, the gambling control board exceptions, I certainly understand why there needs to be some confidentiality with some of that stuff. And marine resources, I'm less familiar with, I think. And so, but that certainly the explanations seem plausible from the agency as to why those exceptions need to exist. I did note there was one, I think it's 2020-54, where the agency actually supports abolishing the exception. So I think that's probably one we should discuss.
I think you're frozen up, John.
And I did note there was another one where the agency was neither for nor against the exception, which I think had to do, or it might be another one.
You're freezing up, John, here and there. Not sure if anyone else is experiencing that. If it would help, maybe switch to audio only. Do we know the one that was neither for nor against keeping it? Do we know what reference number that is, anyone? Hopefully John can come back and he can point it to us.
Yeah, I think it was 2020-53.
Okay.
No, 2020-53 was repealed. 2020-54 was the one that John mentioned, that the agency DMR indicated that repeal might be appropriate, as they felt it was covered by another exception.
Okay, great. I don't see John. He must be logging back in, I'd imagine. So I'm just going to go ahead and, understanding that he might have more comments, I'll go ahead and ask Kevin to identify any by reference number that he had concerns about.
I don't have any additional numbers by reference point. I think similar to kind of how we've done this in the past, I think a lot of times it makes sense for where there's no recommendation of no changes. I think unless there's something that's kind of very clear about the statutory language, for the most part, these are pretty standard exemptions for one reason or another. These are, I don't think abnormal. We'd probably see them multiple places throughout a lot of different statutes. So, I mean, my recommendations would be, obviously we can discuss any ones that other people want to discuss, but I think the ones that are recommended changes, meaning the two repeals, so 2020-53 and 54, I believe are the ones that were already mentioned. I'm on board with talking about those, and don't necessarily see a need, unless others do, to discuss the others.
Okay, great. And before you pass it on, John, did you have, we heard what you were saying about the two provisions. I think we just talked about the one that was sort of neither for nor against keeping the exception. Were there any other comments that you wanted to share?
No, I think it was just that one, and then the one, the marine resources one, where the agency is supportive of eliminating, which I think is Kevin just mentioned. So those are the only two that I had.
All right, great. Kevin, if you could choose the next person to go.
I'll pass it on to Julie again.
Hi, yeah, we seem to be going in the same order. But I can be very brief. I don't have anything to add to what those before me have already said. I do think I'm hoping that when we're approving some of these where there's a recommendation for no change, we can sort of maybe vote on a bunch of them together, do sort of a combined motion rather than having to vote on each one when the time comes. But I don't have anything to add in terms of additional reference numbers. And so I just follow the pattern. I guess I'll pass it along to Linda.
Thank you. I will say I got a crash course in the gambling industry in the state of Maine, which I appreciate, but I don't have any questions about that. The only points, and I agree with pretty much everybody else, 2020-53, I was curious about the lobstering, the collaborative, and then 2020-54 seems pretty clear cut. So it seems like it's those two that maybe I would entertain some discussion about. And so I will hear, who hasn't spoken?
I think everyone's gone at this point, right?
Right, great.
All right, excellent. So what I would entertain is a motion to move everything except for the ones that, except for the provision, except everything except except the recommendations, other than, except for the ones that have been identified as a result of the discussion we just had, and then we can turn to those. And Julie, I think that was kind of what you seem to be thinking, so.
Yeah, I'll make that motion. I think there were the two exceptions, 53 and 54, and then Chris, I think you had 4 additional ones. So with the exception of those 6, I move to approve the other exceptions that were listed in the, I guess there were a couple of documents. I will say the tabled public records exception in titles 8 to 12 for review by the Public Records Exceptions Review Committee, dated by OPLA October 28th of 2021.
Great, we have a second.
I'll second that.
All right, is any discussion on that motion? Seeing none, I think we have to indicate with our physical hands, is that right? The vote?
I believe we actually have to do a roll call, Chris.
I think it's a roll call.
Oh, you have to do a roll
Yes,
call.
roll call.
You're one step ahead of me, John. All right, why don't we go ahead and do a roll call? Who conducts the roll call? Me?
Want me to do it? Or-
Yeah, go ahead, Colleen.
Okay, I'll do it. We'll do a roll call. So those voting in favor, Chris Parr,
Yes.
Kevin Martin,
Yes.
Julie Finn,
Yes.
John Bolton,
Yes.
Linda Clancy,
Yes.
Eric Stout.
Yes.
6. That's 6 votes in favor, no votes against, and that's unanimous of the subcommittee members present.
All right, great. I'll move kind of into the second half now that we've taken sort of the first half of item 1. And what I would like to do is just, I'll just go in chronological order, numerical order, I should say. And I think the first 4 are all mine. So why don't we start it's not necessarily that I have concerns. It's more just in some cases, questions. And I thought it'd be just, I just wanted to take the opportunity to discuss those if anyone felt as though they should be discussed. So with respect to reference number 2020-5, the question I had on that one was, I had two questions. One, this is the one I'm looking just at the table. I'm not actually looking at the statute, but from what I'm seeing from my note, it looks like this is where some personal contact information of individuals is submitted to the Gambling Control Board. And my question there was, there are certain things that are specified. I think it's personal or home telephone and address. And what I wondered is whether or not that should be broadened to include other more modern type personal things, such as personal email accounts or personal social media accounts. So that was my first question on that, and otherwise I didn't really have any concerns other than whether or not that should be updated. And the other question I had about that reference number is whether there's the definition. There's no proprietary information as a term, but I don't think it's defined there. It is defined in various places throughout the statutes. And I went through and I can send you the Peggy and Colleen, I can send you the sites that I found where that's defined, just for your own information. But so those are the two questions I had regarding 2025, whether or not that exception is adequate in terms of the breadth of the type of personal contact information that should be taken into account, and the lack of a definition of proprietary information. So that said, if that's something that is sort of beyond the scope, if either of those are sort of beyond the scope of what we should be talking about, I'm totally fine with anyone saying so and us moving on. But
So can I just clarify, Chris, that
sure.
That we're looking at Title 8, Section 1006, subsection 1, paragraph B. Oh, you're muted because you're polite.
There we go. Sorry about that. What I'm looking at is, so proprietary information is used in that subsection 1006, subsection 1, paragraph A, but I don't think it's ever defined. And and this might go to a latter topic of discussion about, standardizing definitions of things. So we don't have to discuss this now. The other question I had is same subsection 1, paragraph H, where it talks about birth dates, social security numbers, home addresses, and telephone numbers. I just wondered if that should be broadened. They're more comments than anything else. And it's not, with respect to those, there's not necessarily a need to, the exceptions as they are, I think are fine. But I did want to just point those out. Is there any discussion on my lengthy discussion?
Can I just clarify that we've actually listed each one of these paragraphs as a separate item? So number 5 is actually paragraph A. I mean, paragraph B. And I think you were talking about A, right? Which is 4, the trade secrets and proprietary information. Am I have I lost the boat, missed the boat here?
No, I think you're right,
No.
Peggy. So I think we're talking about 2020 number 4 and 2020 number 11.
Okay,
I
Okay.
think that's what Chris, and you might have said 5 before, Chris, but I think,
I did.
okay,
Yeah.
so 4 and 11.
Yeah.
Yeah. So I'm looking at 8, section 1006, subsection 1A and H. So whichever ones, those are my comments on that.
and I think if you're looking at the chart, it's 2020-4 is paragraph A and 2020-11 is paragraph H.
Okay. So what we're learning is it's helpful if I knew how to read the chart, right? Anyway.
I think that's a good point, Chris. Just the proprietary information point in general. Just in my research on this, because I've been kind of looking at this issue from the perspective of trade secrets, and trade secrets is pretty well defined in the case law from what I've seen, and how we apply that and how it relates to the privilege exemption. Proprietary information less so. And when the courts, at least the few court cases there are that they look at, there's proprietary information is defined within the statutes and in each individual case. So I think if we're going to continue to take that approach, I don't know if we can send it back to, in this case, probably you, to look at the proprietary information question in terms of in that unique context, what would constitute proprietary information. But I actually agree with your latter point, which is maybe we should just have this defined broadly throughout the statute with, whether it's the consistency of language provisions that we're talking about, or just a general definition within the statute for what constitutes proprietary information so that we can apply it broadly throughout different agencies.
Yeah, that's exactly what I was thinking, is where, that can be cross-referenced, one-stop shopping sort of thing, where you can cross-reference that definition when you're talking about that type of information. So perhaps that's something, I know we're going to be talking about sort of standardizing definitions at some point, maybe during this meeting. So maybe we could go back to that. As far as the personal information, it's more just one of these things. I know that we updated what contact information was for or for government employees fairly recently, and that did account for these more modern types of ways of contacting someone personally, including email and social media websites. But unless there's any further discussion on that, I think because I misread apparently the chart, I'm going to go to page 19 of the document that includes all the statutes and the chart. And what I'm looking at, it looks like, is Title 12, 6072, subsection 10C. And at the very least, it's 10D on page 19. It's about the lessee annually submitting to the department a seeding and harvesting report, et cetera, et cetera. Everyone see what I'm talking about there, if you're looking? Okay, so my question was, so it looks like the department, it says department shall provide a copy of the report to the municipality or municipalities adjacent to where the lease is located. And what I was just wondering is, once this report is given to the municipalities, does it stay confidential? I wasn't quite clear on that. Maybe it's clear to others that it would or would not keep its confidentiality, but that was my only, not concern, but question, I guess, about that exception. And if there's any concern or anyone has any thoughts on that one.
Chris, I've had my hand up. I don't know if you're looking.
Oh,
at your
yep, sorry,
screen.
I have my, I have
Yeah.
multiple windows going
Yeah,
here.
yeah.
Sorry, Eric. No, I never want to, I
figured
never
you were
want to
looking at-
ignore Eric, so.
No, I figured you were looking at the document. So, but before we leave the discussion we just had,
Yes,
I wanted to add my my theme of the song I like to sing about personally identifiable information. Reinforce your thought process that maybe the calling out things like the home address only, things like that, or maybe a little outdated. And so I would be in support of strengthening anything to include like a personal email address and that kind of thing that you mentioned. And to go further, that those kinds of things, just like the list of items that were added a few years ago for state employees, that those, personal email address and other things for that group of people are explicitly excluded from FOA release. Why shouldn't that be, across the board? So that kind of is a segue into the topic that we're going to talk about later. Are there general provisions that should apply across the board? So the two points there. I agree in this specific instance that could be strengthened, but rather than just trying to strengthen it here and then dozens of other places, it would be more better to have a general provision that we can just reference.
yes,
But that's kind of a longer task. And to me, it's really easy to just add an exemption, XYZ. We have that in section 403, I think it is, that describes general exemptions or specific exemptions, A, B, C, D, E, F, G. We've got, I think, 3 letters left that we could add things like proprietary information or privacy information, and then we go into, double lettering after that, I guess. So anyway, that's my thoughts.
yeah, no, I really appreciate that. And it probably is, the more I'm thinking about it, as far as this definition of proprietary and what we were just talking about as far as definition of personal contact information, seems more appropriate to talk about those type of things in that latter discussion that we'll be having about, what are certain terms that we might have general definitions of rather than have them throughout the statutes, so that there's consistency. And also because for people who have to, refer to the FOA, it's much easier to go to that one place rather than have to be familiar with all kinds of places all over the MRSA. So I appreciate that. With moving back to the report, confidentiality of report, my presumption is that if once they're in the custody of the municipalities, they still remain confidential. But that's not, it wasn't quite clear to me, but I also think that it's not something that I necessarily think we have to discuss a lot. It's just a question in my mind.
Well, I mean, you may want to think about clarifying that, because normally, like if this were a new law, we would talk about it in the Judiciary Committee as this record is now in a different custodian's hands. And what is it that tells that custodian that it's not a public record? And maybe it's obvious because they're turning it, the department is sharing it with a very narrow category of entities, municipalities. But it might be good to clarify that that's not, it doesn't, transferring that document or sharing that document does not make it a public record.
Yes.
I mean, if it were a trade secret and not ensuring that it retained its confidentiality, then you kind of lose that cloak of the trade secret. So I'm not that this is a trade secret, but I mean, maybe that is something you want to talk about.
Yeah. Yeah. Okay. Well,
we can flag, if you want to get through all of these first, have a discussion on what you want to come back to, we can do that as well.
That's what I'm thinking. Why don't we, I only have one more that I had in mind, I think. Again, if I'm reading my documents correctly. My only, again, it was a question, and I think it's pretty straightforward, but there's a few provisions that we that we reviewed where something is requested and then the person who submitted the information or the agency or business is notified of the fact that, hey, this request was made for this information or records, and then there's a 15-day period where they have a chance to do something about it. And it says a person aggrieved by a decision of the agency about whether or not to ultimately disclose the information can appeal that to Superior Court. And I presume that means that if an agency, I can't remember which agency it is in these cases, but it doesn't really matter. If the agency says, yeah, well, we're going to go ahead and publicly disclose this information, I presume that means that the submitter of the information can go to Superior Court to appeal that decision. Sort of a reverse FOA appeal is what's established by that. Is that a fair way to think of it?
I think those are DEP provisions, if
Uh-huh,
sounds
okay.
correct. They'll sound a lot like we have about 100 of those.
I think that's right. I think they're modeled after the provisions that are in your title related to
Yeah,
DEP.
it's all at a 38, 1310B. There,
Yeah.
we
It
treat
is.
those, I believe, I've never had anybody appeal the determinations, but I believe the hook there is an ADC when we issue a
Okay.
decision. So
Okay.
they can ADC appeal us. Whereas the FOA appeal, if we elected not to disclose, goes through the FOA process under 408, I believe.
Yes. Okay. That
But
makes
I don't, that's complicated. I'm not sure we necessarily want to throw those provisions onto everything because it adds about 60 days in terms of when people can review the records because you have to give those 15-day windows. So
right. Okay. That's what I thought. I almost didn't ask the question, but I just wanted to be clear.
I wonder if it makes sense here, if I might add, maybe it's just something that we can put a sentence here that says it remains confidential in those cases, because it sounds like the town has to affirmatively ask for these reports based on the language that I was seeing. So, it seems to be clear that they're aware of the language enough to have requested it via this provision. They should then see that it remains confidential, and that might be enough of a hook to put them on notice, I guess.
Right. And those are you're talking about the reports that are given to the municipalities?
Yeah.
Yeah. Okay.
I think that's the language you were citing.
Yeah. Right. Yeah. That's exactly right. Their earlier language. This language I'm talking about now about that appeal is in a different section, but you've totally answered my question. So I appreciate that. The two other provisions that I noted that were brought up are 2020-53 and 2020-54. Why don't we go to 2020-53 first, if anyone wants to talk about that or have any comments on that?
Maybe if somebody can clarify, but it sounds like the provision was repealed. Do we need to act on that at all at this point if it's no longer?
Yeah, this is kind of a quirky one. It has been repealed by virtue of another subsection of the statute as of October 1st. But the agency's questionnaire recommended continuation of the exception, if you looked at that, primarily on the basis that there was legislation submitted and enacted by the legislature to extend that repeal date for another 5 years to October 1 of 2026. Except the quirky thing is that legislation was not enacted as an emergency, so its effective date was October 18th. But by virtue of the existing law, the section was repealed October 1st. So the legislature's action doesn't revive the repeal. That repeal took effect before October 18th. So technically that section of the statute has been repealed. So I don't think you need to take any action necessarily. the Department of Marine Resources may be suggesting legislation in the upcoming session to sort of reenact that section, since it appears that the legislature did intend for it to be continue for another 5 years, just because of the quirk of the legislative session and the fact that it wasn't enacted as an emergency because the adjournment happened so late. I think the expectation was, when the committee considered it, that the general effective date of legislation would be prior to October 1st, and it just didn't work out that way.
Great, thank you. That's interesting. Eric, you have your hand up.
Yeah, so it sounds like the conclusion is we just table this one to next year after we see what the legislature ends up doing with it. Does that sound right? As far as our role?
Right. I think what has to happen is the only way to reinstate this law is through a legislative enactment. You can't just repeal the repealer retroactively and revive it. So that means that somewhere there has to be a piece of legislation that probably should go to the Judiciary Committee for review one way or another, either because it's coming from the Marine Resources Committee or because the Judiciary Committee agrees to add it to the errors bill because the Marine Resources Committee asks them to. So my intention would be for the committee to look at it and say, yeah, it used to be in the law, but let's apply these, the questions that we usually do on new public records exceptions.
Okay.
So I think Colleen's right. You don't need to do anything. That does not exist in statute anymore.
All right. No, that's easy. And how about 2020-54? Anyone want to speak about that one or comment? Is that one the one where it's just they say it's okay for it to go away? Okay.
Yes.
Yes.
Seems pretty straightforward too. Does anyone have any concerns with it going away?
So my only question is what they said in their response was the department would be supportive of eliminating this section of statute as this exception is no longer needed. I think they really mean that sentence. I don't know that they mean the whole section.
Right. I think that's right too.
Like
But I had that same question, Peggy.
Yeah.
So if you do agree that it should be repealed, I think what we would do is draft something, follow up with the agency to make sure that it, that we would just repeal that sentence. I think, because that's what your jurisdiction relates to, not necessarily the whole section. So we would just let them know that the section would stay, but we take that section out. That makes sense.
Yeah, that makes perfect sense. And yeah, I have no concerns with it. I think we've talked about all the ones that were kind of held. I guess my only thought would be that maybe we accept everything except with respect to, and this is just me thinking, except with respect to that reports to the municipality provision, if that were needed to be identified as one that might need some clarification. So, I guess a motion to accept all the others that we didn't already accept, except with respect to that one, recommend clarification, but I can't make the motion. So if anyone wants to make that motion or doesn't want to make that motion, but a different one, please feel welcome to do so.
Would it be easier to take the remaining? I'm sorry. Go ahead.
Well, go ahead. If you had a question about process. Go for
I
it.
was just going to ask if it's easier to take these 1, 2, 3, 6 separately.
Sure. Yeah.
However you want. I'm just. We're
Yep.
just trying to facilitate here.
Yep, no, you are much better at that than I am. So I guess my only concern is is getting the reference numbers right, since I didn't before. So I guess with respect to the proprietary information related one, which was, remind me,
2024, it amends
2024.
Title 8, Section 1, it references Title 8, Section 1006, subsection 1, paragraph A.
Okay. So with respect to that one, does anyone want to make a motion?
You know, you're going to have other days that you're going to be working on other exceptions. So if you just want to table that for now and wait until after you talk about the maybe some more general definitions for proprietary information or personally identifiable information, you can do that too.
Yeah, I'm so glad you said that, because one of the questions I had is this list the only exceptions? No, I didn't think so. Okay. All
These
right.
are just the
Catching up on
tabled
what we didn't-
ones.
Yes.
Yeah.
Okay. That's what I was. Yeah. Okay. Okay. That's what I was thinking. So yeah, I was hoping to be able to get through all these, but it is 3:42 now, and we do have other things to talk about. So if anyone is of the mind that maybe we should table these for now, that's fine. If we want to try to go through one or a few of them, if not all, then happy to hear that too. Anyone have any thoughts on how to proceed?
I guess, can we make a motion to table the 4 that Chris brought up that might need clarification or potential like language drafted to look at regarding proprietary information, regarding additional details for personal identifiable information, regarding language containing additional confidentiality portions on the town or the municipality. And I'm not sure if we had clarification on 2020-46 or not. I think that's the last one.
I think that if it's the one about aggrieved party, I'm totally fine with that. Yeah, I like that approach. It's a great idea to table just those 3 maybe for now. Sounds like you're saying.
Yeah, so I would put a motion to table those 3. I don't know whether we want to add 2020-54, which is the one that's covered by another, or if we just want to accept that, that covered by another exception piece. I mean, my viewpoint on that was, I think I'm fine with it as long as what they're saying is true, but I haven't done the analysis of the statute to see whether they're going to mess things up by doing that. So I'm not sure whether we want to table that just to get additional, I don't know, analysis done of that claim or not, but I'm open to suggestions.
Can we table that one? I would just feel more comfortable tabling that one with the bulk of them.
That makes sense. So maybe, okay, so the 3 of the 4 that I spoke about, and then the one that you just talked about, Kevin, I understand your motion to be to table those items.
Yep. So I think the motion would be to table items 2024, 2020-11, 2020-44, and 2020-54.
Okay. Here a second.
I'll second it.
Julie, a seconding. Okay, any discussion? Hearing none. Why don't we go ahead and vote?
You need to roll call a tabling motion? Probably, I guess, to be consistent.
Don't know.
Let's be consistent. Yeah.
Okay.
I'll do the roll call quickly. Chris Parr,
Yes.
Julie Finn.
Yes.
I'm doing it in a different order, sorry. But I'm doing it by looking at you on the Zoom. Kevin Martin,
Yes.
Linda Clancy,
Yes.
Eric Stout.
Yes.
That's 5 members in favor, none opposed, and it looks like John had to drop off. So that's unanimous of the members present.
Okay, great.
Those 4 are tabled. So that leaves you with 46 and 53.
Yes. Does anyone want to make a motion regarding those? Is it 53 or 54?
53 is, you tabled 54.
Yeah, so I think the
Oh, okay.
motion is to accept the recommendation of 2020-46, and we
Yep.
don't have to act on 53.
Right,
Assuming they,
right. That's
All right.
right.
Do I
I'll
hear a
second
second? All right. Louis seconds. Any discussion? Seeing none. I think we can vote.
Okay, great. So this is a motion to accept with no change, item 2020-46. Chris Parr,
Yes.
Julie Finn,
Yes.
Kevin Martin,
yes.
Linda Clancy,
Yes.
Eric Stout.
Yes.
That's unanimous. 5 members in favor of the subcommittee members present.
All right, great.
Thank you.
Let's move on now to item 3. And this is with respect to the application.
Chris,
Yeah.
weren't there several others that were no change? And like Julie mentioned, that we would just vote to accept those as is.
You did that.
I thought we did that. Yeah.
That was your first vote.
That was the first vote you took.
Okay, all right. Sorry about that.
Yeah, no worries.
We like thoroughness.
Item 3, application of the 75-year limit on confidentiality on records in archives. And I will maybe, you know what I'll do? I'll just ask Kate, our state archivist, if she would be willing to comment or explain a little bit what the idea behind this.
Sure, thanks, Chris. So as you can see in Title V, the archives has the ability to make any records that are in our possession, so that are archival records at the state archives, if they come to us as confidential, once they are 75 years old, we can make them no longer confidential. We can make them open to the public. We also have to apply any federal confidentiality restrictions like HIPAA, that kind of thing as well. But we have that within records that are at the archive. So that's great. A confusion comes in from agencies in that when records that they are creating and they're controlling are deemed confidential, and then we work with them to try to identify which of those might be considered archival, a really common confusion that we get is agencies saying, well, these records are confidential. According to our statute, they're confidential forever. So they shouldn't even be archival. There's no point in giving them to you because they'll never be shared. So it's just a desire to try to clarify that understanding, make it clearer for folks. I don't know if it's enough to go off of the 75-year limit and just say, well, we have this, and once it's archival, it's no longer confidential. Or if there's a way to put in language into most bills that say things are confidential until or if they transfer to the archives. Helping agencies to understand that there is that way to open them up a little bit. Does that make sense?
Yeah, it makes perfect sense to me. Of course, I think I remember hearing discussion about this idea at one point in the Judiciary Committee. And my immediate thought was not that it was the right way to go, but was, well, maybe the definition of the exception 4023A, where records designated confidential by statute are an exception to the definition of public records. Maybe that paragraph A ought to be amended just to say, records designated confidential by statute, except to the extent they become public pursuant to Title V, and then have a cross-reference in there, or just even say except if once they are archived, they become public after 75 years. But I'll go ahead and like to hear others' thoughts on this. Eric.
So my thought that I mentioned last time is as food for thought, I guess, is, what is the subject or the category of the confidentiality, and are they all to be treated the same? There could be some things that could be made non-confidential earlier. There would be of value to be in the public domain. Other things that may be other categories, broad categories that should always be confidential. So my suggestion last time was to think about, are there 3 or 4 or 5 or more categories that all these individual hundreds of, individual types of records could fall under those broader categories. So just a suggestion to think about that instead of applying the same standard to everything.
Kate, did you have any thoughts on that? And before you go, my understanding is that current law is things that are archived. Once they're at archives for 75 years, regardless of content, they become public unless there's some sort of federal, HIPAA or something like that. But
Yeah, it's once the file is 75 years old. So when a file closes, it could come to us after 25 years after it closes. So we may only hold it for 50 years, but once the file is 75 years old. And I've thought about, because Eric and I have chatted about this a little bit, and I thought about the suggestion of categories. I think the only problem is because we have, archives works in such long periods of time. So we're talking about holding on to these things for 75 years before they're open. Cultural values and understanding of what should be shared and what shouldn't be shared will change over 75 years. So making categories, I think, I'm not positive how well that would work 75 years from now. And how much would we just be going back and saying, well, now we want to change it because our values as a society are different. Maybe they're not, maybe they are. But I think it gets, like, the more detailed you make it, the more confusing it could be long term. Short term, I think it works really well, but long term, it gets more complicated. I think that's the only thing I haven't wrapped my head around how that would work.
Thank you. Linda?
Thank you. Kate, what do other states do?
Most states have some sort of a provision like this, where it says once records come to the archives, they have, after a certain period of time, they are open, and they range anywhere from 50 years to 90 years to 100 years. And then as for dealing with specific, like how you identify confidential records and noting that this archives law will apply, that is all over the place in other states. Some states do it, some states do it specifically based on every record that's made confidential. It's not consistent anywhere.
Julie?
Kate, are you asking for a specific change to the statute or solution to this? Like, what do you want us to do?
I want your wonderful brains to help come up with a great solution, which is, I think, the wonderful part about this group is you all, can bring such really creative ideas. I kind of like Chris's suggestion of just sort of redefining or adding sort of a statement to the definition of confidential records, noting that unless they become archival, in which case they're open after the archival statute of limitations, or however it's best said. Something like that to reinforce to agencies that, yes, you have records that are confidential right now, but they don't always have to be confidential. And if we want to make them archival, we know they will open at some point. Kind of just a way to reinforce that.
So the problem is that agencies aren't aware of the 75-year provision, or the public isn't, or both?
Both, but also the agencies get very confused because they read their statute, and their statute says everything's confidential and it doesn't give an amount of time. So they just read that as forever. So they then challenge us and say, well, we think our statute overrides yours. I've worked with John actually, and we feel that the archive statute actually would override theirs because those records then become the property of the archives. But I think there's still a lot of confusion and hesitation about that.
Kevin?
Yeah, I guess a couple points to that. That would be consistent with my understanding. As soon as it transfers to archives, it's no longer the property of the state agencies, therefore it would be governed by yours. I mean, that's my interpretation of it. I guess my questions would be twofold here is building off of Chris's idea, I think, would it make sense to have language that, unless otherwise listed in statute, allowing for exceptions for particular agencies that it might have, similar to the federal exceptions, if it's required for federal, having specific situational examples where it might make sense to have it longer. And I guess my question would be, are there any of those out there now, or that make it difficult for you guys to deal with, a hodgepodge of different retention periods? I think that's my first question. I do have another one after that, but
I think a hodgepodge of different retention periods get hard to enforce years, decades down the road. But right now, up until recently, it's just really been approached that agencies insist things are confidential and they don't want us opening them up. So I'm having to go in and say, sorry, I'm overriding you. This is what we're doing, which is not a great situation to do. We want everyone on the same page and understanding how it works. Does that make sense?
I think so. I guess my question is, maybe you can't share this, but are there examples of the types of documents that these fights are over? I just can't imagine. I mean, I'm dealing with somewhat sensitive environmental records, but I can't imagine anything 75 years off having something that wouldn't at that point become like strong public value, as opposed to like losing proprietary information or something from 75 years ago. But I guess I'm wondering what situations are causing this issue that warrant, the other side of the story here.
Yeah, I will share there's been some patient records from Maine state managed institutions that I had to enforce that I could share patient records from the 1840s. That was not allowed or fought against for a while. But again, as an historian, there's no reason not to share those. They're so early. There's also, I'm about to share what recently just became not confidential, was the Department of Indian Affairs collection. And we're working on digitizing those and share those. That had a commissioner applied a confidentiality rule to it. It was not in statute anywhere. A commissioner said these couldn't be shared for a certain number of years when it was given to the archives. I'm not sure how legal that was, but that was the case. That time limit has now ended, so we can share those freely. But I can see where there's could be some concern about some of the files in that collection. And I wouldn't be surprised if we got some questions about that.
And then I guess my other question is, I get somewhat related to that, but you mentioned it's based upon the creation of the record, not on the beginning of the retention schedule. Is that right? Because I know with some of ours, like there could be a long period of time before it officially begins the retention schedule, even in agency. I'm just wondering what the dynamic is there with you guys.
Yeah, it's actually when the file closes. That's when the retention period starts. So if a project, say it's a DEP project that's been lasting for 20 years because of research or something, when that file closes and that project is done, that's when the retention period starts. So if that came to us after being in office for another 25 years. It would be the 75-year limitation would be applied to the date that that file closed.
Okay, so I guess I'm just wondering kind of solutions to that potentially could be, because agencies will still have control over their retention schedules. If there are concerns over the 75-year period, and we don't want to, I mean, it's still going to be a hodgepodge, but you could create the retention schedule in such a way, if it's patient records, where it might begin 75 years after the death of the patient, whereas, or something along those lines, where you have extra period of time that will, account for any danger in disclosing things too early.
Yeah, I think there could be some ways we could work with the schedules to address some concerns.
Linda, did you have a question?
Well, my thoughts are going a mile a minute because it's really a fascinating issue, and I can see why it's occupying us and occupying you to nth degree. I guess my question is, if we go down the route that Chris is suggesting to come up with some language, is that something that gets argued, by attorneys and in endless lawsuits? And I guess I see that the issue is more social as opposed to proprietary information, and the Bureau, what was it, the Department of Indian Affairs, is going to be really interesting. So what I don't want to see is you being caught up in a ton of lawsuits arguing over what's personal records that can't be released and what's confidential. So I look to you guys, to you attorneys, to shed some light on that. If we did craft something, what it might look like. But I think it's a really vital discussion right now that we're having. So I don't know.
I think it's a great point. I agree. It's that whole idea of it's the transparency versus ensuring that certain interests are protected. I guess the question I have, well, two questions. First, I assume that for the medical records from the 1840s, you're checking with the people whose records those are, right? I'm just kidding. I'm joking. In seriousness, though, couldn't agencies just not archive? I mean, couldn't they have schedules? I know that our agency has schedules where keep in-house for a certain number of years and then the disposition is destroyed, not archived. So how is that? Explain to me maybe how that works with this.
So that's actually a really fascinating process because the agencies work with the archives records management staff to create the schedules. We try to develop schedules that work really well for the agencies, but they also have to be reasonable for records management. And we're also looking out for what, in our view, is the archival worthy material. What will historians want to see in the future? So there's actually been instances when our Archives Advisory Board have reviewed a schedule and they've recommended things for destruction and they've overturned it and said, no, that really is archival material that shouldn't be destroyed. So even though the agency has asked for destruction, we've said, no, that's not going to be okay. So that's where it gets a little bit messy. We try to always work with the agency as closely as possible to say, this is what we think should be archival and this is why, as well as their perspectives of what they think should be archival and why. But sometimes there are significant events that some agencies would like to not see retained forever, but really need to be.
Yeah, no, that's interesting. It raises a question in my mind. Not that your office has any more work that it needs, because I know you're always busy. But do the record? You know how we're doing this with the exceptions or reviewing exceptions. Does that happen with the schedules as far as, like 10 years ago, this schedule was approved, it said destroy this. Well, we're looking at it now, maybe that's wrong. Is there any kind of process like that, just out of curiosity?
There is. We review and adjust schedules all the time based on either new formats or the way data is collected or different reporting requirements. There's a whole bunch of reasons to update and change schedules. So we do that regularly. It's also a requirement that my position is supposed to approve any records that are destroyed in state government before destruction. So what we do is we look at those schedules, which ones are due for destruction, but we also stop and take a moment and say, does this still make sense? Just because this was scheduled out 70 years ago, does that still make sense? Does that still meet the schedules, other, similar schedules that we've created? So.
Right. No, that makes perfect sense. And just, I saw a hand go up. I will just say, I've been in my job for, over 15 years now. And it wasn't until, I think, Kate, it was you that mentioned it during that hearing that I even learned about it. And that was like last year. So I didn't know about that Title V provision myself. And I feel like I should have. Is it Eric? I think maybe it was Eric's hand that I saw. Anyway, Eric's hand is up. So let's go with Eric.
Yeah, so not to change the subject, but as records become more and more electronic versus physical paper or photographs or whatever, then it kind of changes the dynamic of where you're not just stuffing things into a box and schlepping it over to the archives. You can transfer the electronic file and the agency can keep a copy of it. So it kind of changes the whole dynamic of who has possession and custody if it can be easily replicated. So I don't know if that makes it easier or harder in terms of the confidentiality question and when it reaches the ripe age for that particular record. But I wanted to throw that in there because I'm supposed to be the IT guy member on the committee.
That was actually the same point I was going to make of sorts. Is I feel like the agencies are all starting to modernize as much as possible. So whereas a lot of times these records requests were at points paper until we pile them up, and then the retention schedule is based upon spacing, then it goes off to the record center, which is based upon state spacing before it either gets destroyed or it goes to archives where you determine the archival value. I know our agency is dealing with this, and I feel like other agencies are dealing with trying to make things available electronically to people. And as a part of making those steps, a lot of these are becoming records that are digital and not necessarily kept in the same format. I'm wondering if you've had those thoughts about how, you mentioned value of records changing over the course of 75 years. What about the mediums in which, the records we have that we're going from paper to digital very quick. And I wonder what the next medium from there will be and how this will affect things going forward, whether it's going to make sense. Might be a technology subcommittee question, but I think that's.
I was going to say, I think in many ways it's a whole other topic, but yes, Eric's been a huge part of those discussions about how we preserve digital records. And it's just going to have to be approached in a different way than how we preserved paper. There's still a lot of the same values because it's more, records management is more about the content of the document, the information that it holds, but how we physically do that and how we approach that is going to completely change. We're figuring out how that happens. Don't have really a lot of answers yet, but it will have to completely change how we do that.
So Kevin, you weren't suggesting that we should all go back to paper records, right?
No, not at all. I think I'm more thinking that might be something we want to discuss in the technology subcommittee. That was one of the reasons I was that's the state agency interest there, I think, is to say, everything is getting harder in some ways with electronic records because, we're keeping things longer. It has an impact on, the public's right to know because some people think records are destroyed and they're not destroyed. Some people think they're kept and we lose them. So there's these other factors that are in play that lead up to the archival status of these records where the agencies are still in possessions, or as Eric points out, like we might there might be, it's no longer an easy transition from this piece of paper is in the department's storage room and then it goes over to archives. There might be examples where both parties have, interests in that record. So.
Yeah, absolutely. And the amount of information that we all retain in government now, well, in general, is just growing, I think, exponentially, and that presents its own issues, including in terms of the universe of records that when you get a FOA request, you have to try to take into account and search through. But Linda, it looked like you had your hand up previously, so.
Yeah, just real quick for Kate, were you also thinking of reducing from 75 years to 50 years? Was that on your mind at all?
Ironically, this rule used to be 50 years, and we just increased it to 75 years, like maybe 5 years ago. So we actually made it longer recently. And I'm still comfortable with the 75 years. When you think about a general lifespan of a person, it seems to be reasonable. I don't think I would want to go much more than that if possible, but 75 years seems reasonable to me.
Eric, I see your hand up. I don't know, is that new?
Yeah.
Yes.
Yeah. So the 75 years as far as lifespan kind of plays back into the type of record that would be related to a person's lifespan. But there may be other types of confidential records that really aren't related to somebody's lifespan. Maybe it's related to business operations or government operations or some other aspect of confidentiality that's not based on, like the census is, that's based on somebody's, normal lifespan. But I raised my hand also because as we were talking about transferring electronic records, just to let you know that the federal government has a process now with the National Archives of what they call pre-accessioning, where because it's electronic, they can earlier send permanent records to the National Archives, the Electronic Records Archives at NARA, but then they keep a copy of it for themselves for their own business reference. But I didn't mean to divert that to the whole discussion of electronic records. I was trying to relate that to how it might apply to that small subset of records that are permanent and confidential and conveyed to the archives, and that are increasingly will be electronic in form that could be in multiple places.
All right. Oh, Kate, did you have your hand up?
Yeah, I was just going to respond to that briefly, which is, I think it's a really important point, Eric, in that, while we do have the 75 years, once things come to the archives, I think one thing that committees can always keep in mind is if they want to consider making a record confidential, you could say within the statute, it will be confidential for 30 years or 50 years. You could pick a shorter time, and that would be okay too. I just think in general, most committees don't even think about a time frame.
So how does the committee want to move forward with this issue? Any ideas? Eric.
I really like what the state archivist just said, that if we tie that back to where we're making broader recommendations as related to FOA, that can be one of the things, that going forward, and as we do the annual review on a 3-year rolling basis, also that we kind of bake that idea in when some statutory reference says this information is confidential, that it be encouraged that it be articulated to say, given that there's this default of 75 years, are you aware of that? And if you have a legislative intent to have it less or more than that, then you better say so. And then going forward, that we just take all those confidentiality provisions and try to apply that, that the default is 75 unless the legislative intent is to say less or more so. And then that would kind of drive the scenario where you're not having these fights down the road.
Any other thoughts? Linda, did you?
Did I grimace?
Yeah, I saw your hand go. So
Yeah, I just worry then that, you know, all of a sudden it's 75 years across the board. And that some records that should be released earlier are now automatically pushed to 75 years. That's my concern.
yes, I understand that. It's in the statute now, 75, Kate? Yeah, okay.
Yeah, it's in the archives and records management law, section 95C, as part of the duties of the archivist. It's already in there. It's been in there, you know, for a long time. I don't know. The archives records management law was passed in like 1996. I don't know if this provision has always been in there, but this is the earlier discussion of where the agencies who have their own statutory authority now feel like it conflicts with the archives and records management law implemented by the state archivist. Now you got a conflict because one presumes that it's confidential forever, but yet the archives and management records management law says as soon as these permanent records go to the archives and it's under their legal custody, then that applies. So we got a conflict or a perceived conflict. Unless it's explicit, if people understand that and then it's explicitly said, you know, it's more or less of a time.
Yeah, it seems like there are two important issues. One is we want to make clear the authority of the state archivist and state archives to be able to kind of, for lack of a better term, override, you know, the assertions that might be made later that a record that is supposed to, under the 75-year period that exists, to become public, that there can be an override if there's pushback and, you know, say, oh no, that's supposed to be confidential forever. So there's the need to clarify that. And I think one approach is perhaps just putting that clarification in the definition of public records, in terms of the exception for confidential records, maybe to something to the extent of, you know, saying notwithstanding any other provision of state law, because as I understand what you've been saying, Kate, there's these federal laws, so we couldn't really accept things from that. But, you know, notwithstanding the provision of any other state law, these records become confidential pursuant to, after 75 years pursuant to Title V. But the other important issue is and I be curious to hear people's thoughts on this, because it's occurring to me as Linda was talking, is it within this subcommittee's or the Right to Know Advisory Committee's authority or whatever to make a recommendation about the 75-year period that exists? And I'd be curious to hear others' thoughts on that. I'm going to infer from the silence that is not within our authority, unless someone else says differently. Kevin, you went off mute, so
I don't think I have any insight necessarily about the 75 years, but it might be within our authority to, and I think I mentioned this when in our survey, was, does it make sense to add a question to the questionnaire when we do these exceptions reviews, to have the person responsible for applying or the agency responsible identify what they think is the appropriate period for confidentiality, so that in future years, when we're reviewing, titles 13 through 40, we'll have at least a recommendation that says, these should be less, if they think it should be less, or it could default at 75 years if there isn't one. If we're going to be looking at these kind of piecemeal, it seems like that would be where it would make sense to do so. Because it really would at that point just be one question that they have to add to kind of analysis they're already doing.
Yeah, I think it's a great idea. I don't think we would need statutory authority to change the questionnaire. One thing that it's a great idea, Kevin. One thing that occurs to me is also I wonder, and I think this might need statutory authority, is whether that should be added to the list of considerations when new exceptions are proposed. If this is confidential, okay, well, what's understanding that the default period of 75 years should, is that too long or not long enough? So that might be something that we might want to ultimately, as a subcommittee, make as a recommendation as well. Julie, you're off mute, so.
Yeah, just a couple things. I mean, I think that the period of time, whether it's 75 years or any other period, that's really a legislative kind of policy determination. And in fact, Kate said that was changed just maybe 5 years ago. So I don't think we wade into that. That's my opinion. I also think there is an ease of administration kind of thing we need to watch out for. We can't have, I don't think Kate would want a different period of time for all sorts of different types of records or different agencies, or however you split it up. It could, that could be cumbersome, could be costly, it could be, a lot of things. And one last thing I just want to throw out there. Kate came to us that the issue was more that seems like folks at, some agencies are not aware of the law that already exists. So I don't know if changing the law is really the fix here. It might be like an issue of education. It might be, I don't know if there's something like an attorney general's opinion. Because out there, previously we talked about, if which trumps what, like with the archive statute, does that sort of trump the agency's determination that it's confidential forever? I think Kate said it does, that's like a legal determination. Is that something that's been like researched and written about? That's the kind of thing I would think the AG's office might do. And that would be kind of a public, review and a public, researching of that topic with a conclusion. Just throwing out ideas here.
Yeah, so speaking as the representative from the AG's office, we have had discussions about this provision internally, and with me on behalf of representing archives and folks from, say, the DHHS division, where a lot of these issues come up because they have the sensitive records from long ago. And I think within our office, there's, as far as I'm aware, there's widespread agreement that that this 75 years rule trumps whatever the agencies think. And I haven't gotten any pushback from anybody on that. And I think it's pretty clear. I honestly, I think a big part of the problem, or not the problem, but the issue is just the fact that it's in a strange spot in the statute, and it's a little bit buried, and it's in a paragraph that starts out talking about rulemaking. And so it's positioned oddly, I guess, in the main revised statutes. And I think that is part of why people aren't aware of it or are confused by it. But when you actually sit down and read the language, I think it's quite clear. And I don't know if it's worth it to, move the language to like its own letter under 95C. I'm not sure that it is, but I do wonder if like that in itself would solve part of the confusion.
John, what about if it were added rather than creating a new letter under the exceptions? If it were added, if some language was added to paragraph A about, records that are designated confidential by statute, there was some sort of elaboration or even a cross-reference to the Title V provision. Do you think that's even helpful?
A cross-reference, and I'm sorry, where are you talking about, Chris?
So one of the first exception that's listed under the definition of public records are records designated confidential by statute. And I just wondered, my original idea was maybe just qualify that somehow, except to the extent contemplated at Title V, whatever the section is in subsection. But just real quick, I agree with what Julie said. We don't want to make this too complicated, especially when you have not only records that are designated confidential, but information in records. So it's like you'd have to review each record to see if certain information, well, this year we can disclose this bit of information, but not this, but not this other one, until next year. So it can become very confusing. But do you see what I'm looking at, John, there?
I do. Yeah. I would have to, I guess I'd want to give it a little more thought. I do wonder if other records that are protected under, B through whatever it is, V, also, I think they also become public after 75 years, right? So it's not just records designated confidential by statute.
Oh, that's a great point. I hadn't even thought about that. Maybe it's something that we make the change up in the actual definition of public records, as opposed to in the subsections or in the exceptions parts. But,
yeah, and then the thing you always worry a little bit about is that if there's legislation that when you propose legislation, it tends to make people think that it's actually accomplishing something in terms of changing the law in some way, and you can address that with statements of purpose and that sort of thing, but we wouldn't want to send a message that we think this needs to be fixed because it doesn't, the 75 years doesn't work, doesn't apply otherwise, because obviously we think, I think it does, and I think my office, as far as I'm aware, thinks that it does. So, so that's just one cautionary note as well.
Well, and on that point, I guess, if your office, John, is confident that, I guess I want to make sure that there's no, that there's clarity. Yeah. And if there's clarity at your office and Kate has the authority to be able to push back and that is going to be supported, then, I guess I see the need for a statutory change is not necessary. But if there's any ambiguity that would, cause that bright line to not be there, that would be my concern.
Yeah, and I don't want to overstate it. I would say that, basically that, this issue came up, reached out to the people that represent the agency, the specific agency, right, that might have concerns, and they were in agreement that the 75-year statute trumped after some, back and forth about it. But, I don't want to suggest that there's been sort of a decision from the top, that the AG himself has looked at this and made a determination, because it's been much more informal than that. So, I suppose this could come up if we have a different agency, right, that's represented by a different AAG that might look at this and come to a different, might have more concerns. So I don't want to overstate it, but I will say that, so far there hasn't been any. There's been unanimity of views on this when I've brought it to folks' attention.
Thank you. Eric.
Yeah, so I just wanted to, Chris mentioned earlier that even though he's been on the Right to Know Advisory Committee for like 10 years and staff attorney to the Maine State Police for longer than that, probably, I think you said you weren't even aware of this. So I see that as a major problem of awareness and baking it into the, the FOA definition of confidentiality and referencing over to the Title V would be a good idea. Making the committee drafters aware of that as a default 75 years for records that are permanent that go to the archives is a good idea. And also considering that maybe that provision in Title V, the archives records management law that says 75 years, maybe consider unless there's a specific statutory time frame elsewhere. In other words, it's sort of the default unless there's a legislative intent that specifically calls out an exception to that. So maybe that's the way to bring more awareness to it, but also make it not just, hard and fast that there's one rule always with no exceptions.
Speaking for myself, this is making me think a lot, and I'm not sure I could, at this point, think of a way forward. But it's not an issue that I think we should just finish talking about. I tend to think maybe it's something we should think about until the next meeting, but what do others think?
Hey,
Evan?
Chris, can I just mention from a
Yeah.
drafting standpoint, this is Peggy,
Sure. Yep.
that I think the legislative drafting perspective is in total agreement with John that you don't amend a statute when you're not really doing anything. So a couple things rise to the surface in my brain right now. One is Section 403 of the Freedom of Access Act is definitions. And we try not to put substantive law in definitions. And we also try not to put flags in the statute that aren't doing anything. Every once in a while, we might do that. I think there is like a little bit of a flag in the criminal code with regard to protection orders, and a violation of a protection order. Although the protection order isn't issued under that provision in Title 17A, it flags it and says, here's what those violations are. So I guess I'm not really sure how you would redraft the definition of public records and their exceptions. I'm wondering if there's another place where we can make sure that people are looking at Title V with regard to public records. And actually, I just pulled up the public law chapter that created Section 95C in Title V. And it also amended kind of the policy statement for the archives, which includes, it is also the policy of the state to ensure that the records are preserved for the time required, established pursuant to these the schedules. And so maybe we also, and maybe John's right, maybe that's where you say, and that these records become public. So it really stands out in the archive statute or something like that. I'm rather than kind of having it buried there, that I'm just concerned that the whole drafting standards of how we do definitions wouldn't really incorporate a cross-reference that's not an actual part of the definition, if that makes sense.
Yeah, it makes perfect sense. And I certainly wouldn't want us to recommend something that is, sort of a strange approach in terms of drafting and such. I mean, it certainly sounds like there's a need for people to learn about this provision, an educational aspect of this. And, I don't know, Peggy, if you were suggesting, though, that a statutory change might be made in that section you just were talking about, and maybe that's what we ought to think about.
Maybe that's something you want to think about, and maybe, Kate wants to react to that as well, because maybe that doesn't serve the archivist's purposes to have that kind of in their policy statement.
Yeah, Kate, do you have any thoughts on that?
No, actually, I think it would be good to highlight it anywhere we can, as well as in our policy statement. And I think that because so much of the purpose of the archives is to make records available, freely available. And that's a strong statement of our purpose, a major point of our policy of why we exist. So I think that could make sense. I am really intrigued to hear about it, at least the issue of the length of confidentiality becoming part of the criteria when developing new legislation. I'm intrigued with that idea as well, because I think unless you're in the role like the archives is of thinking long-term, it just wouldn't occur to you. No matter where we put it in statute, it's why would it occur to you? So putting that within some sort of a framework as new legislation is considered, that would be just as a reminder to say, hey, stop, think, put some thought to this.
Kevin?
Yeah, I think at this point, I don't think I'd want to recommend any statutory change. To me, I don't know if we can do this, but it seems like we possibly could consider this as the full right to know group as a part, and then maybe put a recommendation in the report. I don't know if we can do that, Peggy, but maybe as put some sort of recommendation in our report at the end of the year that recommends additional education. Maybe it's something that they can get put in when records officers get trained. That won't help longtime officers, but it would help those who are new to the process understand that confidential provisions have limits. It might, when I believe the legislature goes through records training, it would, or new state selectmen or council members go through training, I believe, and it might give them opportunity to understand that when they're putting these provisions in, that there's a limit. I think that's the best we could do at that point. But I think from our perspective, it makes sense to maybe just do a recommendation and report that memorializes this discussion and maybe another discussion amongst the full committee.
I'm thinking about time. Looking at the clock, we have 21 minutes. And I appreciate what Kevin just said. I wonder if we need more time to make a decision about this, including, because I don't know, do we have to make a recommendation to the full committee, and I'm not sure what that recommendation would be at this point. And then we also have two other items on the agenda that we might have 10 minutes each if we proceed in a way that budgets equal time. So is there, in my mind, I do think this probably needs a bit more conversation, if only to decide what we recommend to the full committee. But does anyone have any thoughts on that? Oh, Linda?
I agree with you wholeheartedly. I think if we can have a little bit more discussion.
Anyone else? Is that suggesting a tabling motion of some kind ought to be made about this item?
I'll move to table.
I'll second that.
All righty. Motion table. I don't think that's something that could be discussed. It's not subject to discussion, right, Peggy? Tabling? So,
Right, if you're following official like legislative rules, right?
well, I'm trying to do that. So, so I guess we need what, a roll call, or
You want a roll call to table?
I don't think you need one, right? I don't know.
Oh, well, let's just do it real quick.
Okay.
So the motion is to table this discussion for a later meeting. Chris Parr,
Yes.
Linda Clancy,
Yes.
Jonathan Bolton,
Yes.
Eric Stout,
Yes.
Kevin Martin,
Yes.
Julie Finn.
Yes.
Okay, that's 6 in favor of tabling and none opposed.
Excellent. Okay, why don't we move right into, it's 4:41. Why don't we move right into standard confidentiality language? And maybe Peggy, if you could kind of say what the general idea is behind this item, if you know.
Right. So if you remember that report that our office was required to provide, we just had some recommendation. It's really odd for our office to be able to recommend something, but we were just trying to recommend really standard basic language going forward for public records exceptions. And the first step, I think, was for years, and I've kind of been part of this discussion, there was an idea that calling something not a public record was different than saying a record was confidential. And we really haven't found any support for that other than just general discussion. And in fact, in looking at the lettered paragraphs under subsection 3 in section 402, what's a public record? And all these things are not public records. There are a couple of things that actually say, you know, this information or this record is not a public record, but it can only be shared in these circumstances, which is kind of how we were framing what a confidential record was. And so we think that the legislature's intent, if we can, think about that going backwards, is whether it's not a public record or it's confidential, it should really have the same treatment. And it makes sense to, when you're outside of the Freedom of Access Act, to refer to things as being confidential and not worry about any other references to it not being a public record or, not a public record for the purposes of Title I, Chapter 13, or any of those things. If it's a confidential record, you say this record is confidential. If you're going to allow it to be shared with law enforcement agencies for criminal justice purposes, you say that it's confidential, except that it may be shared with law enforcement, so you're very clear about it being confidential and how it can be shared. And then if there are some records that are so confidential that they're not even subject to subpoena, like the death review records, those are supposed to be, systemic analysis of what went wrong and how do we fix it. We don't want those involved in litigation. So we specifically say they're not available they're not subject to subpoena or any other compulsory process. And because otherwise we assume they are, even if a record is confidential, we assume a court can order otherwise. And if I'm going down the wrong path, I really hope John will stop me. So that's just kind of what we're recommending, to try to make sure that we have standard language, at least going forward. And then also, as the Right to Know Advisory Committee keeps reviewing things, we can standardize the language. And that's kind of the idea that the Judiciary Committee was looking for, we think. Maybe if we're standardizing language going forward, we can also think about the discussion you just had about how long things are confidential. Not that you would actually put that in statute unless you're going to deviate from the default.
That's great. Thank you. Does your office actually, has it actually drafted language that we would look at?
So in the report, we have some examples about different situations. So, and I can share those if you want. So we kind of just, it's confidential, or it's confidential, but it's authorized to be disclosed to a certain person or for certain purposes. You know, some records are confidential only temporarily. You know, bids on contracts, construction contracts, sometimes those are all confidential until the bid is awarded, and then everybody can see what had been, you know, sent in for a bid to make sure that the government is, you know, making those decisions reasonably. Sometimes there are conditions on when things can be, confidential records can be released. And then I think one of the things you talked about, and maybe this is something it's one of those general things, is, okay, individual information in these records is confidential, but the department can release a report that summarizes the information as long as no personally identifying information is released or it's released in the aggregate. And actually, one of the exceptions you reviewed from the Department of Marine Resources, the statute says they can't release information if it would identify who it came from, whether it's a vessel or an entity. And because there's only one entity that falls into that category right now with the department, that means they can't release that information because it identifies, you know, whose information that is, because there's only one. So they're not releasing that information, and the National Marine Fisheries Administration would be interested in that information, but the statute says they can't because there's only one entity. I don't know if that's something you want to address, but anyway, that's kind of the aggregate or summarized information. It's not really, it's an exception that it kind of overrides the exception because you're keeping the sensitive information confidential, but you're letting the aggregate information out into the public.
Okay.
So I don't know if you want to, I don't want you to spend a whole lot of time on this right now, unless you have taken the time in preparation for this meeting to read all these different exceptions. And it might make more sense to talk about your other pieces about, are there, you know, broader categories that you can define to make public records exceptions easier to understand throughout the statutes. The general definition of proprietary information, the general definition of personally identifiable information.
Yeah, you're reading my mind, because I wouldn't be able to really, I'd want to see, and I haven't seen the language that you were just talking about. And so, you know, my thought is that maybe if that's something that we were to have a chance to look at before the next meeting, that this item be tabled. That's just my thought. Any other thoughts?
Yeah, just so everyone knows, that was one of the first set of documents that came out from Peggy or Colleen. That was included in that tranche of records. There was like a 5 or 6 pager where they listed several examples and then their recommendation. So, you know, maybe resending that, Peggy, fresh would be helpful.
Absolutely. We've posted it on the subcommittee's website for this meeting, but we'd be happy to send it. And we'd also be happy, if it makes sense, to just pull out the examples and say, here are the examples that we think would work going forward when the legislature says, we want this record confidential, but we want it available in these other circumstances. if it made sense to create a document that just had those examples in it, that might be easier for you to go over. But that's, that's assuming that when the legislature says it's not a public record and the legislature says it's confidential, it really does mean the same thing. We think it should, but you don't have to go along with that recommendation.
Yeah, I mean, I certainly wouldn't want to create more work for your office, Peggy. I guess if there is an easy way to create a standalone document that has all that. Otherwise, I'd be fine with just resending what you already sent, or sending a link to what's posted, whatever is easier for you. But yeah, but is there any kind of interest in a motion to table this till the next meeting so we can look at those things?
I have a question first, but then I'll submit the motion. I guess
Sure.
Those are examples, and it sounds like the solution is these are recommendations for the legislature to consider when drafting future language. Is that correct? Okay.
Yeah.
It sounded like you didn't find other examples that went counter to that. I guess I just wanted to, maybe when we discuss this later, see if we can have a broader discussion about some of that, because there's probably merit to the argument that they're different. I just wondering what there might be out there, if there is anything, or if we have more detail into that topic. But that can be tabled for later, and I'll motion to table.
All right.
Second it.
All right. No discussion, and I guess we'll go to a roll call.
All right. Motion is to table this topic. Chris Parr,
Yes.
Kevin Martin,
Yes.
Julie Fenn,
Yes.
Linda Clancy,
Yes.
Eric Stout.
Yes.
5-0. I don't see John in the meeting anymore, so.
All right, great. The next item, and we have about 7 minutes to talk about it. Maybe let's call it 5 minutes, given the planning we have to do, is broad categories of confidential records information in FOA. And what's been helpful is that we've already had a couple of examples of this sort of thing, where can we consolidate all the definitions of proprietary information, for example, into one definition that is easy to reference and everyone knows it means the same thing wherever you see it. And I know there was another one, but I'm not going to try to think of it. Any thoughts on how to approach this from anyone?
PII was the other one that I had suggested, and I think I've been singing this song as well as some others for a long time. What more of a top-down approach rather than a granular, dozens of exceptions that basically say the same thing that are sprinkled throughout any of the 30-some statutes, titles. But we don't have time to really delve into it, and we're all tired, I'm sure. So I would suggest, I'm a big proponent of this. I've been proposing this idea, particularly with personally identifiable information, because of my background in the federal government. In 2005 and 4 and 5, I was a member of the Federal Interagency Privacy Committee that met every couple of months over at the White House Conference Center. And I was HUD's Assistant Privacy Act officer. So I've got some deep experience with, how the federal government does this. And of course, this is state government, and we're not a little federal government, but I just see that the whole federal government treats, personally identifiable information through the Privacy Act, and it's very mature, extensive network of privacy officers and laws and practices and policies and regulations and training and penalties and all kinds of things that pretty much don't exist here in the state. So I guess my way, if we can't get a Maine Privacy Act, which you had proposed a couple of years ago and I endorsed, it didn't make it, voted like 7-8 or something, didn't get out of committee to go forward for consideration. But I think if we can't do that full-fledged, I think at least if we can have personally identifiable information as one of the A through Z items added. We have 4 letters left in that alphabet. PII, such as PII for that's carved out for state employees. You can't release their personal email address and other things. But if we could have a PII as one of the XYZ letters left, that's what I think makes sense. And then whenever that question comes up in any of the agencies or programs or in these 30-some titles, they don't have to try to compose something for that particular thing, for the gambling control board or whatever. If it's a PII, if it's personal, it's off the table. In other words, it's by definition, this is how the federal government's been doing it since 1974. If it's personal, it's not public. Simple as that. So I guess we can't fully discuss this more, and I've been rambling on, but I would suggest that we carry this over for another meeting and then for the full committee to consider also. That's my thoughts on it.
Thank you. Anyone else have any thoughts? I think this is going to be the sort of thing where, we're going to come across words or what have you at points down the road that we hadn't even thought of that should be universally defined. My thought is that maybe we between now and the next meeting, if everyone wants to maybe table this item, is to think about, based on your own experiences, what terms might be worth us taking some time to consider during this session of our subcommittee meetings, to try to maybe either identify as words that need or should be have a uniform definition, and maybe the next step is to try to create a uniform definition. I suspect that's going to be might be the more difficult part, depending on what terms are at issue. So those are my thought is we have 1 minute, so we clearly are not going to resolve this. But if we want to, if anyone's interested in making a tabling motion, so we can give this some more thought, that is one way to go.
So moved.
Okay. I see a second from, I think, Kevin.
Yeah, I'll second that. And I think, frankly, we probably have enough topics based on tabling to plan the next meeting at this point.
Yeah. I think you're right.
Plus you have all the new public records exceptions to review, which we'll be getting out to you probably tomorrow. Sorry.
Looking forward to it.
Well,
Right.
we can send you the questionnaires right away. What we don't have is the linked document of statutes. And if that's useful, we'll go ahead and send you the questionnaires. And actually each questionnaire, if you click on it, it will link you to the internet copy of the statute. So we can send that to you because you can start working on it then, because I know you have nothing else to do in your life. Okay. So maybe you want to just schedule the next meeting.
Yeah, well, I think we have a tabling motion.
Oh, right. Sorry.
Yep.
All right. To table the topic about broad categories, Chris Parr.
Yes.
Kevin Martin. I think he said yes. Julie Fenn.
Yes.
Linda Clancy.
Yes.
Eric Stout.
Yes.
Okay, that's 5-0. 5 in favor, 0 against. John Bolton's not in the meeting.
And that was a yes. I didn't realize he's muted, sorry.
Yeah, okay, thank you.
So it is now 5 o'clock. As far as, let's move right into planning. One thing I would want us to think about between now and the next meeting is, do we have too much work such that we're not going to be able to meaningfully address each topic? And that might be something that we should talk about maybe at the next meeting, if not now, but we don't have a lot of time now. So what are you thinking, Peggy, in terms of, do you have dates to propose, or would you want to send out an email later to ask what availability is like? How would you like to go?
I'm happy to do however you want. You have, 5 of your 6 members here. If they have calendars available and can figure that out, then maybe that's the way to go. But I'm happy to work any way you want. So the next meeting of the full advisory, I'm assuming you're not going to try to squeeze one in before the next meeting, right?
I don't
So the
think so.
next meeting is November 10th. And after that, you don't meet again. There's Thanksgiving that intervenes, and then you meet on Wednesday after Thanksgiving, December 1st. So if you want to try to squeeze another meeting in between there.
So the week of the
Maybe the week of the 15th.
15th. Yeah. What I'm thinking is, in the interest of time, is maybe if you were to send out an email just asking which dates during that week.
Okay.
If that makes sense. Eric, you have a question?
Yeah, what would you consider, because sometimes, some years we've done subcommittees in the morning and then we have the full committee in the afternoon. So when we're meeting the 10th, would you consider us meeting to try to knock out some of the, finish up some of these discussions that morning, and then we can bring it to the committee? I'm just afeared that we might run out of runway because the full committee only meets 4 times and they've already met once, plus the voting on the policy for remote.
Right. We're not
So
counting
just to
that as,
consider.
it is one of the meetings, but the advisory committee can meet more than 4 times. So we still have 3 more meetings scheduled. One of those is the 10th. If you want to meet on the morning of the 10th, that would be great. And maybe that helps you identify if the standard confidentiality language, for example, is something that you think the whole advisory committee should discuss rather than just in the subcommittee. You could make that recommendation for the whole advisory committee to take that up, or something like that. If you're concerned you have too much work to do a good job on all of these topics, maybe you send it back to the advisory committee as a whole advisory committee issue.
My thinking on that is, what for those of you who are on this call right now, the members, actually everyone on this call right now, what is your availability like on the morning of the 10th?
I'm free.
Too.
Yeah, I look like I'm free too. The advisory committee is 1 to 4, right?
Yes. Right. It might not last all the way till 4.
Linda?
So seeing as how I'm driving over to Augusta for that meeting, right? Is there?
You don't have to.
No, I think it's important that we do.
Okay, good.
Go with the policy. But can we push it later in the morning? Like, could it be 11 or?
You mean, so it would be a hybrid meeting or you could do an in-person meeting as well.
Yeah, I guess that depends on others. I mean, I was planning to go to Augusta, but if you wanted to meet via Zoom. Yeah, I guess that's the complication.
Okay, I got you. You could still do a completely remote meeting and you could be doing it from wherever, right? You're remote. So you could be at the State House to do it.
Yeah.
Yeah. How late would you need us to start, Linda? Were you thinking 11?
11 would be great if others agree.
And is the thought maybe a work for till like 12:30 or something and then take a break?
I guess it depends if others are going to be in Augusta. That's the deciding factor, if we're going to be gathering in a room or if it's going to be hybrid.
I had planned for these to be all remote, but so that's my preference. But I will defer to my fellow committee members as to how you want to do this.
It is a complicating factor, though. It makes it a little trickier to have the meetings in the same day, because I think I'm planning to go to all the, the big committee meetings in person. I kind of feel like, based on my questions last time, I'm supposed to do that. But I like that these are remote. I think that's nice and it's convenient for us. I think it worked out well today, and it could on other days.
Yeah, I think the policy we adopted, which is following the intent of the legislature, as Representative Harnett said, I think a lot of us would like to just go remote, 100%, but he expressed that the intent of the legislature is that the default is to be in person, which puts us in a hard spot. So Peggy, that's going to be an in-person meeting, the full committee meetings, right? Unless you're over 60 miles away.
Right.
Hour away.
We have scheduled it as a hybrid meeting. So we have the technology to do it as a hybrid meeting. So we don't have to have a quorum there. But people need to meet the policies, definition or criteria for not being physically present. So you're right. 60 minutes, 60 miles.
Yeah, I'm only 30 minutes, so that means I have to be there in person.
That's why you wanted to clarify whether it was just one way. Right. So, I mean, there's also concerns about health and safety. If you have concerns about being in a room with other people, that is a concern. I understand. The legislature's policy right now is if you're in legislative spaces, you are required to be wearing a mask or, over your nose and mouth. And after you have self-screened and met all the criteria to be present in the building. So it's up to you how you are interpreting that policy for you. If you're not going to be there in person, though, you do need to either let one of the staff people know or let Tom Harnett know directly.
Any other thoughts?
So is it possible just to do it on a different day that for this committee instead of the same day? I'm only factoring in having a meeting remote and then getting in the car and driving an hour for an in-person meeting. So that's my complicating factor.
Sure. I'm sorry, that week, is that what you're thinking? Next week, I guess it'd be next week, right?
Or the week after. I mean, did we want to work in another meeting before the full committee meeting? I guess I'm unclear on that one.
Yeah. It's really the preference of the subcommittee members, I guess. I mean, I feel like we've talked a lot and there's stuff that I certainly want to review before our next subcommittee meeting. And plus next week is a short week. So because of Veterans Day. So yeah, I mean, but if the consensus is to meet next week, we will make it happen.
So would it just make things easier if I send out an email and ask people to respond to either, I think the only day that you could meet next week is probably that Wednesday morning. Or I guess you could meet on Friday or the week of the 15th.
Okay. Is Monday out, Peggy, next week?
Monday, well, sorry, Monday's out for me because I've got the Criminal Records Review Committee meeting that day.
Oh, okay.
But Colleen might be available and Rachel might be available to meet with you.
Okay. Yeah, if you could send out an email that asks availability for next week and the following. That might be the easier way to go.
Okay. Okay, and you're expecting like a 2-hour time slot, right? 2 to 3.
Let's make it 7 hours.
Yeah.
No.
You are not the judiciary.
Yeah. Yes, probably 2 hours is.
Okay.
Yep.
Okay, great. We'll do that.
Excellent. All right. Last item is to adjourn. Do I hear a motion?
So moved.
Do I hear a second?
I'll second that, and I just wanted to say thanks for our state archivist to participate in this great discussion, a full 2 hours. I think it's great. The more that there's synergy between records management and FOA and IT, it's all good.
Yep, it's great words, Eric. I totally agree, and certainly, Kate. Please, we'll continue to be discussing one of the items, so that you've been involved in the discussion about next time. So please, I hope you can make it.
I definitely will. Thank you.
All right. Well, everyone who wants to adjourn, I guess I'm just going to assume if you don't want to adjourn, please speak now. I don't hear anyone. All right. Have a great night. Take care.
Thanks.
Thanks, Chris.